sometimes the biggest risk to somebody's future is not that they died, but they had a stroke, or they lost capacity because of dementia, or some accident caused them to have some kind of brain injury. These things unfortunately happen. A good estate plan will always prepare for that by having what I call living documents. I call them living documents because these are the documents that are essential to have in place while you are alive. Those are your durable power of attorney for finances, your durable power of attorney for healthcare, and your healthcare directive. It's also called an advance directive. It's also called a living will. It's not a will, but it's called that. That's where you put in your wishes if you are at end of life and the doctors say, with all reasonable medical probability, this person, no matter what treatment we give them, it will be futile because they are terminal or in a permanent vegetative condition. That's where you make sure your voice is heard. Do you want that or do you not? Do you want to be allowed to die without heroic measures, or do you want heroic measures? It is your choice. Make sure your wishes are in writing and known. That's your advance directive. Who will speak your voice? That is your healthcare agent under your healthcare power of attorney. That person should know you, should know your wishes. And you know what? I do want to say, often it's not that uncommon that people don't have a family member. You might be single, and there's nobody that you would want to be your healthcare agent. There are professionals who know what they're doing, who have a fiduciary responsibility to be your advocate, your agent, and they will speak for you. So keep in mind that if you're I don't know who to appoint, your attorney, their job is to sit with you, talk with you what options are, and bring you to a place where you're comfortable with the resolution of who you have chosen. In any kind of power of attorney, don't just name one person, name an alternate. And if you can, name another alternate. So there's, for example, 3 people, my husband, my daughter, my son. Don't make them joint. Have them have independent successor first, then second, and third. We see a lot of problems when people have a joint type of decision making. This isn't supposed to be a committee. This is one person that you designate in the first position because they know you, you trust them, they will do right by you, they will be your voice, and that's who you appoint. You'll also want a durable power of attorney for finances. I already mentioned earlier about what happens if you don't. You will be a court award of the state in a court-ordered guardianship, conservatorship, with everything being public. Avoid that. Have a good, durable power of attorney. When it comes to what do I mean by a good, durable power of attorney, we come from an elder law perspective where we know Medicaid strategies. We know how to protect assets in case of long-term care costs. So in ELG's estate planning documents, we will discuss with you having authority to revoke a community property agreement, enter into a separate property agreement if you're married. Remember what we talked about with Fred and Betty? If we knew he was going to die, we'd want Betty to give all the assets to him. Well, if Betty has dementia, she can't sign any documents, but fortunately for them, they did an estate plan before she lost her legal capacity. So her agent, her durable power of attorney, can sign a document that's a separate property agreement that says everything now is going to go to the spouse who's dying so that everything can come back into the trust for the surviving spouse. So that's the type of authority that an elder law attorney might include. Then an estate planning attorney would go, why would you want to do that? The reason they say that is they don't understand how we do Medicaid strategies and how we can protect more assets. We understand how to do that because we file Medicaid applications. We do Medicaid asset preservation strategies. Knowing what Medicaid's rules are, we're going to make sure that our clients have robust, durable powers of attorney to protect them in all ways that are possible. So that's just one example of what would be included in a good durable power of attorney. So we've been talking about an older couple. I will say that everyone needs an estate plan. Some people seem to need it more. Obviously, as people get older, there's more of a sense of urgency. So they're more likely to meet with an estate planning elder law attorney and get it in place. But anyone who has any level of assets should have a estate plan. And frankly, anybody that has no assets, because an estate plan isn't just a will or a revocable living trust. It's those living documents we just talked about. For those of you who can recall back, I'll mention the Terry Schiavo case. That was a situation, very tragic, where this person lost all of her ability to manage her own affairs. And there was quite a dispute between her husband and her parents, who would be making decisions for her. So this all played out in a very public scene where if there had been for this younger person, durable powers of attorney for finances, for health, and a healthcare directive, we never would be having this discussion. But it does happen. So regardless of a person's age, they need living documents.